everybody. I'm so excited you're here, if you couldn't tell already. This is a webinar I've been looking forward to for quite some time because I think background checks is just one of those mystery boxes. So we were lucky enough to get Jerry Nielson of TruDiligence, CEO of TruDiligence, to kind of shine a light on all of that for all of us. Yeah, Jerry, if you'd like to take it away, I'd love to, have this kick off.
Awesome. Okay. Thanks, Danny, so much. Appreciate you for helping us get this set up and for hosting us today. And thank you, yeah, for everybody that has joined us thus far. So today, what I'm going to do is I'm going to give a little bit of just a background checks 101 presentation. And I always kind of preface this by saying that some of what we're going to go over might just be old hat for some of you that have been in industry forever. But I always find when I give this presentation that there is benefit to just having it all kind of just wrapped together in a nice little bow put on the box and just to help prop you up with some information in terms of what your background check company may be doing in the background for you. And I think the information I'm going to present is obviously applicable whether you're using TruDiligence or not for your background checks. We hope to hopefully create a relationship with you out of this effort, but certainly what I'm going to present, I think, is not unique at all to TruDiligence, and I just think it's good information that will help us along the way. So really what we're going to do today is we're going to do just candidate background checks. Generally speaking, what's legal, what's not, what's extra, what we should be doing, what we shouldn't be doing, when we should be doing it. So with that, we'll just go ahead and get started. So the first thing I always have to do, this is one of my least favorite slides in the whole PowerPoint deck, but our attorneys made us do it. I always have to do this. I am not an attorney. I'm not an FCRA attorney or an employment attorney. I'm more of a consultant in this respect. And so anything that I give you, because I'm not an attorney, isn't to be used as legal advice specific to your situation. Obviously, we always recommend that you consult with your own legal advice for any issues that might be specific to your organization that would be outside the scope of anything we're going to go over here. So with that said, we'll get the nasty slide off there. And today, a little bit about me. As Danny said, my name is Jerry Nielson. I'm the president and founder of TruDiligence. We are a background check company based out of Denver, Colorado. Formed in 1993, so we just had our 30th anniversary this previous December. We are Better Business Bureau A+ rated, and we are also nationally accredited by the Professional Background Screening Association. With that, I'll go just a little bit about what our agenda for today is. And so what I really intend to do is to cover these six topics, right? So we're going to go over a little bit about the Fair Credit Reporting Act and what that means. Everybody knows the FCRA, they know the lingo, they know the acronym, but nobody necessarily always understands exactly how it has implications to what we're doing on a day-to-day basis when running background checks as a background check company or as agency owners, right? I'm going to touch just real briefly on disclosure and release forms. I'm going to talk a little bit about what to run and when to run it. I'll talk a little bit about implications of ban the box and what that means for those that may be dealing with that or have that on their horizon or are not familiar with that. And then also my report is done. Now what? And finally, I'm going to talk just a little bit about adverse action processes and dispute resolution, because that's really important within this realm, should we be taking action on the contents of the reports. And so we will get started with all of that. So first, just a little bit of history on the Fair Credit Reporting Act. So the Fair Credit Reporting Act was established in 1970. And people have a very common misconception with the FCRA that because it says credit in the title, that it only applies to an applicant's credit report. And that's absolutely not true. The act should have been renamed many years ago to be more of a broad consumer protection act, but ultimately it is still the Fair Credit Reporting Act. How it applies to our industry and to you as agency owners running background checks is it defines and really is the manual and the Bible, so to speak, for the background check industry. It is the overarching federal regulation that governs everything having to do with background checks, right? So it defines a consumer report. And I'll talk about each one of these a little bit individually. It defines a consumer report. It mandates the disclosure and release processes. We all know that we need to get a disclosure and authorization form to conduct a background check. A lot may not understand that that is coming directly out of the bones of the FCRA, right? So that is absolutely where that requirement is written into federal law. It drives report content when we're compiling the consumer report. It also drives all of the adverse action processes that I am going to touch on in a little bit later in the presentation. And finally, it also drives and mandates all of the dispute and reinvestigation requirements, right? And so much of what we do is rooted in the FCRA. So I think it's important that we kind of establish that as the foundation for everything that we're doing, because that's where most everything is driven out of, right? Beyond the federal level Fair Credit Reporting Act, there are also state level FCRA implications, right? And so there are many states and municipalities that have jurisdictional laws that may also need to be taken into consideration beyond the federal Fair Credit Reporting Act, right? And so we've got our FCRA, which is overarching at the federal level, and then we may have state and even municipal level lookalikes to the federal act that also have bearing on everything that we're doing. And I'll talk a little bit about those also. So just a little bit of historical context on where a lot of what I'm going to be going over is being driven from and how the FCRA applies. So let's talk just a little bit about disclosure and release forms. And again, I know that some of this is just old school for everybody, but it's interesting to me. I mean, as recently as day before yesterday, I had a conversation with a prospect who was still just getting an authorization statement signed on their job application, and they had the impression that that was compliant, right? And so I had to have this educational discussion about, under federal law in the FCRA, that the disclosure and release forms are very specific, right? First of all, we know that they are mandated by the FCRA, and that both of those must be in writing, right? And what's most important in that is the disclosure and the authorization, but the disclosure must be separate from the authorization language, and the disclosure must notify that a consumer report is going to be prepared and provide the name and contact details of the agency who will prepare the report, right? And so because it's got to be separate, they need to be standalone from any other job application or any other process that or documentation that you may have within your hiring practices, right? Beyond the disclosure, then we also have to get authorization. We must be granted permission to have the report prepared, right? Neither of these documents, and this is something else where there are a lot of concerns over the disclosure and authorization process, neither of these documents should contain any extraneous language. So a lot of times you'll see an authorization document, if it's not been updated to step in line with modern regulations, it'll have hold harmless language in it, for example, that says, yes, I authorize this background check to be done by TruDiligence or whoever the background check company is. And as part of that authorization, I agree to hold harmless XYZ nannies and TruDiligence as a part of this process. And I waive any rights I have to, take action in this procedure. All of that has been deemed to be non-compliant. And what I will say about these, just to kind of wrap this part up, is very, very, very large companies with very, very, very deep pockets have gotten sued and have put out millions of dollars in damages over the last 10 years based simply on failures in their disclosure and authorization language, right? So I'll have a takeaway slide here near the end of the presentation, but absolutely, absolutely, if your disclosure and release process has not been reviewed by legal counsel in the last few years, it is absolutely a takeaway from this that you have your disclosures and authorization reviewed and that language signed off on by legal counsel to make sure you're compliant, because there are two areas under the federal FCRA that are probably the most highly litigated areas in the entire background check realm. And that litigation comes against agencies and agency owners, right? And their background check companies. Number one is disclosure and release processes is far and away the most highly litigated area within the background check realm. And the second one is the adverse action processes, which I'll go into here in just a little bit. So I harp on this because there is a tremendous amount of liability in the design and the content and the preparation of your disclosure and release forms, right? It seems like a simple step, but they've got to be right. They absolutely have to be right. Okay. So beyond disclosure and release forms, let's talk just a little bit now about the process, and let's just talk a little bit about the background check life cycle, right? So applicant has applied. We've obtained disclosure and authorization forms separate from the job application to allow us to now run a background check. Great. Let's order a background check, right? What should I be checking? Obviously, with any background check company out there, there are any number of dozens of types of searches that could potentially be run, right? And so what I do is I try to boil this down into at least kind of a minimum best practices. And then you'll see in a moment, I'll talk a little bit about ways in which you could consider enhancing that, right? So in terms of minimum best practices, I feel like at least is a good place to start. At a minimum, all agencies should conduct at least the following background checks on every candidate, right? And so that is a trace on the applicant's social security number, which helps us validate their identity, and it helps us drive any additional potential criminal records research that we're going to do, because that social trace is going to give us name and address history based on that applicant's information, right? And so then we use that as a roadmap to determine what additional searches may need to be done, right? The other thing I like about the social trace is it's a wonderful place just to check and make sure the applicant has been truthful with you about who they are, what names they've used, and where they've lived, right? And so it's a great tool to just cross-check what comes back on the official social security number trace when it's completed by your company against the disclosure that the applicant gave you or the authorization form where you may have asked for address history. And we just simply do a quick review to check for holes, right? Red flags go up. You tell me you've lived in Cheyenne, Wyoming for the last 2 years, and I trace your name and address history through the social trace, and I see address history from somewhere in Utah 6 months ago. Obviously a red flag should go up, right? So that we can see and help identify discrepancies in the data when we're doing that comparison against applicant supplied information and database driven results off of the social trace, right? So then beyond the social security number verification, obviously we're going to roll into criminal record searches, right? And so obviously I think you should be doing statewide and or county level felony and misdemeanor checks in the locations where the candidate at least currently lives, right? And I'll expand on that in just a moment. I also think the National Sex Offender Registry is obviously very applicable, and also a driving record if your nannies or your placements are going to potentially be doing driving as a function of their job. I know some do, some don't. I think at a minimum, these are at least the bare minimum things that we should be looking at, right? As we go forward in terms of possible recommended best practices, now let's expand on what I would consider that to be a basic search, right? I think in addition to the required basic background components listed, the recommended best practice would be to conduct potentially these following additional checks. Those felony and misdemeanor checks in every jurisdiction which the candidate has worked or lived in during the past 7 years, right? I think at a minimum, you're checking obviously their current address at the state and or county level. But then I think beyond that, we look at that address history and we assign felony, misdemeanor, criminal record searches against all known address history for some designated look back period. You may choose to use 5 years, you may choose to use 7 years, you may choose to use 10 years. Depends on how deep you want the background check to go. But I do think running obviously criminal level background checks against every address that is developed is really wise. I also think that the National Criminal Database is obviously a tool that we have in our arsenal that we can check. So I do think that you look at potentially supplementing your localized state and or county level criminal record searches against the National Criminal Database, right? I also think it's important that we're checking every name used by the candidate during the past 7 years, uh, having had a check for criminal records, right? A lot of times people skip over aliases, right? The social trace develops other names that may not have been encompassed within the base background check, and so taking that consideration in when the person has previous names with many and probably most background check companies, all of the research is conducted by name, by date of birth, right? And so when, for example, as a provider, when we order a background check at the county level from a court clerk, Judy Smith and Judy Jones might be the same person, but at the court level, those are two separate criminal record searches, right? And so a person having additional names within their history has bearing on whether or not those need to be done. And also, just so you know, I'm keeping kind of an eye on and I know Danny is as well, keeping an eye on the chat queue, a little bit on the background. So I'll try to definitely answer some of those questions as we go down as well. The question is, and this is a place where I can stop and do that for sure, wondering what really is the difference between a background check modestly priced and one that is extremely expensive? How much should we spend? That's an excellent question. And so generally speaking, if we're running a social trace and we're running county and or state level criminal record searches, we're running the national database, we're running potentially an OFAC as it's known, or a most wanted lists, I would say an average price point for that, assuming that we've got one name that we're dealing with, is probably somewhere between $30 and $40, right? If you've got a background check company that's charging you more than about $40 for that, I would consider that to be pretty high, right? So yeah, I 20, we've got a package that we offer throughout the community that's about a $32 package, $32.99 or thereabouts, $35.99, that runs everything that we're talking about here. Does a social trace, does county criminal or state level criminal record searches against all known address history for the last 7 years, supplements that with the National Criminal Database, does the national sex offender, does all the most wanted lists, and we can do that for somewhere in the low to mid 30s, right? And so certainly you can go beyond that. And so when we start talking about something that's a bit more expensive, usually what you start finding there is, yes, you've added a driver's history into that package. Your applicant may have multiple names, right? Adding aliases into that process may certainly take that package price up a little bit because we're running additional names, right? There are other things that can certainly build onto that package, right? If we're doing interviews with previous employers or agencies, and we're wanting to do an employment verifications, or if there's training certificates or something of that nature that your particular family may be wanting to make sure that your nanny has and carries, certainly those things can increase the cost of the general background check. And so I think the question there really is, you shouldn't be overpaying for what I would consider just a best practice search. It would be really more so if you're adding additional searches into that, then that can certainly change that, right?
Jerry, can I just ask you a follow-up
Sure.
to that?
Go right ahead. Absolutely.
I don't want to derail the whole thing, but I am wondering, and I feel like I'll forget, when with like different aliases, like would that be like a maiden name and like a married name, or like what is like aliases?
A good question. So yes, so really in the background check realm, an alias would really be a distinct change in the last name, is the easiest way to think about it, right? So those would be previous marriage names, maiden names, things of that nature, right? What we don't really consider an alias, or at least a billable alias, would be a Robert that's also being checked as a Bob, right? Or a Marianne that's also being checked as a Mary. If your researcher is doing a proper job for you, you should be picking up what we call wild cards on the first name, right? And so, Robert is checked as Rob, Robert, Bob, Bobby, Robbie, as many different variations as we can come up with, right? A true alias would be a distinct change in the last name, right? And that's how we would consider that as a true alias, right? Yes, good question.
Thank you. Thank you.
You bet. So yeah, the last 2 points here is conducting annual updates to existing background checks on temporary nannies or babysitters. I think that's super important. A lot of times people do a once and done, right? I see that commonly, that they run a background check on a placement upon hire, and then that background check may never be refreshed, right? So definitely give some consideration to whether or not you have a need to do ongoing and or annual background checks to refresh that nanny's background check, right? The way I generally talk about that is you have just as much liability for your placement's future actions as you did for their previous actions, right? Great that we caught that they have a DUI in their history. What about the DUI they're going to get next month, right? Hope that never happens, but we know that that's the world in which we live, right? And so there is liability there. So give a little bit of thought to potentially refreshing those checks. And then I think finally, which is just a best practice, protecting candidates from identity theft by utilizing background screening companies that do not engage in the offshoring of candidates' SSNs, dates of births, driver's license numbers, while they're processing their background checks. What I will say is that there are a lot of providers within the industry that do use overseas data providers. I don't see that as a best practice because I just don't like to see our applicant or citizens' data rolling outside the U.S. borders. We don't know what's happening to the data at that point, and so that's a little bit one of those obscure thoughts, possibly, but do give some consideration to the sources in which your background check company is using, and that they're not using overseas call centers, they're not using support mechanisms that are outside the U.S. In my opinion, it's better to keep that within U.S. borders, just from a protection standpoint in terms of your candidate's data, right? Okay, moving on. When do I search? So let's talk just a little bit about when to conduct the search. Obviously, the first tripwire is we've received a disclosure and an authorization form separate from the job application. I'm going to keep pounding on that because that is significantly important, right? So we've got our disclosure and we've got our authorization form. Beyond that, when can I actually conduct the search? And I could do an entire 4-hour session about Ban the Box alone. So I'll just touch on it really lightly here because this can get really deep and it will get us out in the weeds just a little bit, right? But generally speaking, just recognize what Ban the Box is. And so for those that don't know that term or haven't heard that term, for those of us that are of a certain age, right, will remember a time when, back in the day on a job application or in this application process, we asked the candidate to supply, have you ever been arrested, convicted? We all know the question of previous criminal address, or previous criminal history. What happened was, several years back, a lot of states started implementing what they call Ban the Box, right? Do not ask that question. Put a ban on the question. Do you have prior criminal record activity, right? They called it Ban the Box. That's what it's really become known of. Implication of Ban the Box really, as I say here, Ban the Box refers to asking about prior criminal activity and oftentimes dictates when the search can be conducted, right? That's what's most important. It's not so much Ban the Box has grown into this huge animal that indicates not only do you ask the question, but also when can you run the background check? Forget whether you ask the question or not. When can I actually conduct the background check, right? And so I'll suffice it to say that if you're in one of these jurisdictions that I have on the slide, and I'll make this deck available to Danny after the session today so that he can make it available to the community. So don't feel like you got to feverishly scribble all these things down. I'll make this available to everybody. If you're in one of these jurisdictions, absolutely speak with your legal counsel about the implications of Ban the Box, because at least as of the time when I made this slide, which was a few weeks ago, this was an accurate list of jurisdictions that have a Ban the Box implication in some way, right? And so just know that that is a thing, and it may have implications on when you run your background check altogether, right? Okay. Finally, I've got my report. Now what? Here are some common questions that I get. First of all, what about report sharing, right? people ask about reports within the agency realm. Report sharing is commonplace, right? Our families want and need to be able to see the contents of the background check report, right? What does the law say about that? The law is a little bit, I won't say silent on that, but it doesn't have that pinned down specifically. What it does say is that the report should not be shared without people that are a part of the context in which the report was generated, right? And so legal counsel, I think, would generally indicate that report sharing is okay, but it is obviously only recommended upon authorization by the candidate and with a use certification from the family, right? So within your paperwork that you're doing as an agency owner with your family, legal counsel would typically say, make sure you've got a statement in there before you share reports with any of them, that they understand that they're going to be privy to sensitive applicant data, right? PII, as they call it, right? Personally identifiable information on a nanny candidate, and that they agree to keep that in a confidential status and not to share it beyond this relationship. They can't take that report and then go share it with anybody else, right? There has to be some sort of boundaries in the report sharing. Yes, as an agency owner, you can make that report available to the family, but you need to make sure you've got some controls that dictate what the family can and can't do with that, right? And so we just call it a third-party certification, right? And so we get that certification from the family. The other question I get commonly is, what about applicant copies? I've talked to a dozen attorneys about this in the industry, and frankly, they all will tell you, don't buck the applicant on getting a copy of their report. It's their report. Are you absolutely legally obligated to give them a copy of the report? Likely not, except in a few jurisdictions, right? There are copies required in some states. California, Oklahoma, and Minnesota specifically have laws on the books that applicants in those jurisdictions have to be given the right to request a copy in this process, right? Beyond that, it's not necessarily absolutely required in the law, but all you're going to do is irk your candidates a little bit when they ask for a copy of a report that was prepared on them if you give them pushback on receiving a copy, right? And so the best practice there is just simply, if the applicant asks for a copy, give them a copy, right? It's simple. Make a copy available to them. If they don't want to get it from the agency and they want to get it from the background check company, most background check companies take a similar approach. If the applicant requests a copy, we'll give them a copy, right? There's no reason not to be honest with you, right? So just a couple key points there: report sharing and applicant copies. Okay, now for the fun part, and I'll move through this a little bit quickly because I think everybody probably knows a lot of this, but understand that now that you've got your report back, we've addressed report sharing, we've addressed applicant copies. Now let's say what happens. Remember what I said at the beginning, what were the two areas that are the most highly litigated? Disclosure and release forms on the front side, adverse action processes on the back side. So that's why I think it's really important that we take just a couple of slides here and run through the adverse action process, right? So when your report comes back from your background check company and you're going to take adverse action, negative action against that candidate based on the contents of the report, there are some very specific steps that are laid out in the Fair Credit Reporting Act that have to be followed. And if they're not, there is a tremendous amount of liability in this process, right? So again, the adverse action process is mandated by the FCRA. And in the employment context, it is a two-stage process, right? So under the adverse action rules of the FCRA, for employment purposes, two steps. One is a pre-adverse stage, and the second is the actual adverse stage. And there is a waiting period in between those two stages, right? So the pre-adverse stage basically is, to break it down in layman's terms, I've got my report back from my background check company. I see something here that is going to prevent me from being able to place this candidate for whatever it is they're trying to be, right? I have to do a pre-adverse notice, right? So what happens is a pre-adverse packet, as we think of it, goes out. And in that pre-adverse packet, there is a pre-adverse action notice. It's a one-page letter that basically says you authorized XYZ nannies to run a background check through ABC background check company. We've done that background check, and we have found something within the report that may, there's the kicker, that may potentially cause derogatory action in our ability not to place you. Therefore, enclosed with this notice is a copy of the report, so you can see what it is that we are looking at. You can check it for accuracy. And if you find something that you want to challenge, then you do have a dispute process available to you. And here's how you engage that, right? And I'll talk about disputes in just a minute. That pre-adverse action packet goes out. It then goes into a waiting period. The FCRA is somewhat ambiguous about what the waiting period is. It says a reasonable amount of time is exactly what is in the law. So millions of dollars have been spent in the industry having attorneys try to figure out what a reasonable period of time is, right? How do you define that? The general consensus is it's a minimum of 5 days, right? 5 business days is the best estimation of what the law is intending there. You can use more than that. If you choose to use less than that, that's perfectly fine. But generally speaking, a minimum of 5 days is the waiting period. Over that period of time, you can picture what's happening. The applicant has received the packet. They're looking at the report. If they see something in there that they feel is inaccurate or incorrect that they want to dispute, they have the ability to do that. If that 5-day waiting period goes by and we don't hear anything, or you don't hear anything from the applicant in terms of a dispute, then it moves into the second stage, which is at the actual adverse stage, right? At that point, there is a second notice provided to the candidate that is the actual adverse notice, not the pre-notice, it's the actual adverse notice, right? And that adverse notice says pretty much the same thing, except it's not you may, remember my kicker, may be denied, it is you are denied at this point, right? That is when the actual adverse action occurs, is when there was an opportunity for the candidate to review the report. There was no dispute that was filed. There were no changes to the report. There was no reinvestigation. And we are now actually at the adverse action stage, right? And so then the adverse notice goes out, and that's the official denial. And that is technically when the adverse action itself is entered, right? So pre-adverse, waiting period, adverse absolutely has to be followed if your candidate is being denied based on the contents of a consumer report from a background check company. Okay. All right, so let's go into that just a little bit. And I kind of got a little bit of my head here from the slides, but I'll run through these really quick. So on the pre-adverse action notice, before you reject an applicant, reassign, terminate an employee, deny a promotion, anything that could be considered adverse to the actions of the candidate or adverse to their interest in this transaction, let's call it, right, is going to be needing pre-adverse action, right? There's a lot of arguments about, well, what if it's, what if I do this? Is it really considered adverse? Does it rise to the level of needing an adverse action process? Don't try to get around it. If there's something in the report that is the basis for your decision, put them through the adverse action process. There's just too much liability not to, right? So the pre-adverse notice obviously goes out with a reason for the action. You include a copy of the report, and you include a document that's the FCRA mandated summary of rights, right? It's a document we've probably all seen. It's available from your background check company. It's available on the Federal Trade Commission's website. It's a 4-page in its current form, 4-page document that's laid out by the Federal Trade Commission, and it's called a summary of your rights under the Fair Credit Reporting Act. That absolutely has to go in the pre-adverse packet, right? Then, again, the purpose of the pre-adverse letter is to help minimize the possibility of the applicant being denied placement without him or her knowing that they were a victim of insufficient or erroneous information. Giving the permission, the notice in advance gives them the opportunity to review the report and tell you if it's correct, or is there anything that they want to dispute, right? Then we go into our waiting period. 5 business days, right? Employers must wait at least 5 business days after sending the pre-adverse notice, allowing the applicant time to file a dispute for discrepancies found in the report, right? Now let's assume really quick that if you take adverse action based on the information from this report, you give the applicant or employee notice of that. It can be orally, it can be in writing, or it can be electronically, right? Got to include the name and address and phone number of the consumer reporting agency that supplied the report, so they know who to contact if they want to file a dispute. It's got to have a statement that the consumer reporting agency did not make the decision to take the unfavorable action and cannot give specific reasons for it. In other words, Your background check company is not the one making the decision. They simply prepared the report. So we're not able to comment on the reason the agency or the reason the agency made that decision, right? That information has to come from the agency. And finally, a notice of the person's right to dispute the accuracy or completeness of any information that the Consumer Reporting Agency furnished, and to get an additional free copy from the Consumer Reporting Agency if the person asks for it within 60 days. That's what's got to really actually be in your adverse action notice when it goes out, right? And so this is straight out of the FCRA. If your adverse action processes do not contain these elements, you're not compliant, and you are creating liability for yourself by not having these pieces plugged into that process, right? And again, I'll make these decks available for anybody that would like them. Let's talk really quick about dispute resolution process. Over that waiting period, the applicant has the ability between the pre and the what's called the post or the actual adverse notice. They have the ability to file a dispute, right? They get the report, they see something in there, they think they've been misidentified, or they've got something being reported as a conviction that was not a conviction, or whatever the reason might be. They have the ability to file a dispute resolution process. I love the graphic in the top of this slide too. That shows a lot of what we deal with in the dispute resolution process, right? And I think we all can probably relate to that. If you've ever been on the phone with an applicant that wants to dispute something, that's sometimes the way it goes, right? So applicant may file their dispute with either the employer or agency directly, or the Consumer Reporting Agency directly. They can go to either channel, right? And both of those contacts are put in the packet when it goes out. If a dispute is filed, the Consumer Reporting Agency has 30 days in which to complete a reinvestigation at no additional charge to the applicant. Your background check company is legally obligated under the FCRA to go back and check their sources, check with the courts, reconfirm the information that was in the report, look for anything that may be reported in error, right? The courts are not infallible. We'd like to believe that the courts are 100% accurate all the time. It's just simply not the case, right? It doesn't happen often, but there are times that they get a date of birth, mismatched with an applicant or something input backwards, and all of a sudden it's matching somebody that it doesn't belong to. And so the federal regulators have forethought that, and that's what the whole reason that they've got the dispute resolution process built in this to begin with, right? 30 days to reinvestigate. If the reinvestigation results in a change to the report, an updated report is distributed to both the applicant and the employer. Makes sense. There was a change to the report, so now we've updated the report to both the applicant and the agency. And then the final part about that is the Consumer Reporting Agency does have the right to terminate a dispute reinvestigation if at any time it is deemed frivolous, is the word that's within the FCRA. We take that occasionally from time to time. An applicant that's frankly just trying to wiggle out from under a charge that is probably them, but they're filing a dispute and they're trying to hope that maybe somehow it can be removed from the report. At any time, the Consumer Reporting Agency does have the right to terminate the reinvestigation if it's deemed to be frivolous, right? And if that's happened twice in 30 years, it would be a lot, right? But it just know that there is that mechanism there. And this is important. In the dispute resolution process, I think this is an excellent hint. Empathy goes a long way in avoiding lawsuits, right? If you take a call, listen to me on this. If you take a call from a candidate that has a question about their report and they feel like there's something inaccurate or there's something that they want to challenge, if they get somebody on the phone that is empathetic, compassionate, caring, understands that that is a traumatic experience, I'm applying for a job and now you're telling me that I may not get that job because there's something within my report, but I don't believe that something in my report is me. There's been some sort of an error in this process. I think this is common sense, right? If they get somebody on the phone that is compassionate in that process, their next call after they hang up is not likely going to be to their attorney, right? If they feel, now that's within their right. I'm not saying they can't call their attorney, but generally speaking, most people are not going to take it down that road. And you want to avoid that road if you possibly can, as do we, right? And so I just think it's a good point. And I think that's with anything in life, right? Empathy goes a long ways to avoiding, any hardships in many, many types of situations. But just know with disputes, that should be your white glove team. whoever your white glove team or your white glove person is, get them their gloves out and have them put them on, right? I mean, that needs to be handled with the utmost care and delicacy, right? All right, couple things, and we're almost here to the end, and I'll see if we got any questions when Danny opens it up. Record keeping. My desk used to look like this. Luckily, with technology nowadays, it doesn't look like that so much, but I think a lot of us have dealt with this, right? This is obvious, right? In the record keeping process, think about it this way. When I talk to people about these entire processes, reverse engineer it from the point of litigation, right? I think that's critically important. You're standing in front of a judge because of some action that a nanny or a candidate has filed, right? And what are you going to have to present? Reverse engineer your defense before you have to stand there and defend something, right? And so obviously with record keeping, document everything. And I think we're all good about that in this world these days. But if you're going to take adverse action, log it. When did the notice go out? Make sure you're compliant. Document that you started the waiting period. Document when the adverse notice went out. If there was a dispute, document that there was a dispute. Put together a timeline, put together a life cycle of those actions so that in the event that there is some sort of adverse litigation that may come against you as a part of this process, you obviously are standing there with the tools that you need to adequately present a defense, right? So record keeping is obviously very, very important in this process. All right, we're up to takeaways. So if I summarize all this into just a few bullets here, obviously, look at your process, as I just said, from a litigation standpoint, right? So much of why we're doing background checks is multifaceted. I could list out a dozen reasons easily why we're doing background checks, and I think we all know that. But the primary reason is litigation, right? We're wanting to avoid litigation. We're not wanting to place a candidate within an environment that harm could be done, right? We're trying to protect our families, and we are also trying not to get sued, right? In that process. So look at your processes from a litigation standpoint and reverse engineer them to make sure that when you are standing there, you've got the appropriate tools, right? Consider the implications of the FCRA and state regulation. Review your disclosure and release forms. I'm going to harp on that for the fourth time. Review your disclosure and release forms and make sure they're compliant, right? Review your report sharing and applicant copy policies, right? If you're sharing reports with families, make sure that you've got those certifications that I'm suggesting. If you don't, talk to your legal staff about what you should have in place in order to legally and safely share the report from your background provider with the family. It's just could just be a simple paragraph within your agreement that addresses that, but it needs to be addressed, right? Finally, review your adverse action procedures, including dispute resolution policies, right? Be thinking about that. Just know that when you're taking action based on the contents of the background report, you absolutely have very specific steps that you need to follow, right? And then I think also evaluate your background check procedure. Are we meeting minimum requirements? What are the minimum requirements for you? That may be different from agency to agency. What I gave are some general guidelines, right? But that may be different. Think about best practice add-ons that I suggested. What's in my package, and is it meeting my need? If I don't understand what's in my package, then I should probably get somebody from my background check company on the phone and ask the questions. Don't be afraid to ask questions. Make them lay out for you exactly what they're doing, right? There's no reason that they should not be willing to disclose any of that information to you, right? Finally, be consistent and follow written procedures, right? Document, right? Pretty common sense stuff there, I think, but it's just certainly good to think about those things as we kind of wrap all this together in one box. Finally, just real quick here, and again, I'll make this deck available. I've got some resource links here. You guys don't have to necessarily scribble this down really quickly. I'll make this available, but I do on here have some resources. There's a link here to the Fair Credit Reporting Act in case there's any questions about that. There is also a link to a really good article that was written. It's an opinion letter that was written by the FTC with regard to using consumer reports and what employers need to know. It's an excellent resource. There's also a document that was published in April of 2012 by the EEOC. Although that document's aged, it still applies. It talks a lot about how the Equal Opportunity Employment Commission would look at the use of criminal records specifically within the employment context, right? So if you have interest in studying that a little bit, there's a really good document there. And finally, this is a really good document from SHRM's website, actually, Society for Human Resource Management, that talks a lot about ban the box and how that has morphed over the last 5 years or so, and how it has implications in some ways beyond how it was initially intended, right? So I'll make these available. They're hyperlinked within the PowerPoint. And so finally, we are at questions. And I know we got a little bit of time probably left. If we go a full hour, it's what, 11:48 my time anyway. So any questions that that I can answer with regards to any of that?
Yeah, does anybody have any questions? Because I actually have, I feel like a curveball question, but I know you all came, so I want everybody else to have the opportunity before I pester Jerry with mine. All right, I'm gonna go for it then.
All right.
What do you think about like agencies having like a background check on families because of like you're putting a candidate in this other person's house? I know I know of one agency that does that, and I was just wondering what you thought.
I was just going to say that I actually have had those discussions kind of as of late. And, I mean, I absolutely think that you are, I don't think that's as commonplace, right? I mean, I do think that's outside the general sphere, at least with today's practices. But I mean, I think there's a duty to understand who you're dealing with on both sides, right? I mean, I think you obviously need to understand the history of the candidate that you're placing within that family's realm, but I certainly can think of probably many arguments I could make for why a background check on the family that you're placing with is just as well, if nothing else, to protect your agency and your nanny as well, right? You're not just trying to protect the family, you're trying to protect your asset, your agency, right? And your reputation and your nanny, right? Or your placement. Good question.
Thank you. Does anybody else have any questions? I know it can be intimidating, but to just speak up and throw one out there. But if you're here, I feel like you probably came for a reason.
Do you also verify education?
Yes, ma'am, we sure do. Yep. Employment, education, references, licenses, certifications. Absolutely. Yes. Yes.
Ellie
Okay.
says, yeah.
Go ahead. I'll let you read it.
Sure. Is it legal, appropriate to have candidates sign paperwork holding them responsible for the cost of a background check should they fail to start a position after it has been run?
That's a good question. It's an excellent question. One I get often, actually. And what I'll just say about that, generally speaking, is that can vary from state to state. There are states, and I don't have a list of them really available, but there are states where you are absolutely prohibited from having the candidate in any way, shape, or form cover the cost of their background check or sign any reimbursement or clauses of that level, right? So there are certainly places where that's absolutely legally acceptable, and there are other places where it's not. So that's probably a good point to speak with your legal counsel about in your location specifically, just to make sure there's no prohibition. I will say that probably broadly speaking, that's more accepted than not, right? So I think generally, in general terms, having the nanny cover the candidate cover the cost of the background check is acceptable, but there are certainly carve outs in that where that absolutely cannot happen. So you'd want to look at that jurisdictionally. Good question. You're welcome.
If you have to like do the dispute, like somebody's like, that's not me, I'm certain of it.
Right.
What would we do? Would we like, in my mind, I would probably just call TruDiligence and be like, this person thinks that this is not them. What do we do now? But I actually have you here. So what do we do now?
All right, perfect. Yes, for sure. So when the dispute comes in, The really important thing there is they can file that directly with your background check company or with you, either one. It just needs to be accepted, right? If they're going to start a dispute, you can't say, well, you didn't report it to me, so it's not a valid dispute, right? It needs to happen. And then ultimately, yes, say that comes to you directly, then you're going to reach out to your background check company and say, hey, this applicant is wanting to file a dispute. That likely comes in after the pre-adverse notice has gone out, right? Now we're in the dispute resolution stage. And so that allows us an opportunity if we're doing the adverse action process for you, right? Your background check company may offer a service to do that as a fulfillment service. They don't make the decision, but they'll prepare the notices and they'll log it and they'll audit track it and they'll actually do it as a fulfillment service, right? Or you can do it internally, right? That's why I kind of harped on that. You know, if you're going to do it internally, certainly very legal in doing so. Just make sure that your notices meet what I had laid out in the slides, right? But beyond that, yeah, notify your background check company that a dispute has been received, right? And then usually the background check company would likely, I would anyway, reach out to the candidate directly and just say, you know, we are the provider, we're the consumer reporting agency. We understand that there's a dispute here that is in front of us, and we just want to make sure we understand the nature of the dispute. What is it exactly? You know, I've had these things come in where they're like, oh, the whole thing's wrong, right? And it's like, I know that, I just know that's not correct, right? And so, you know, we have to pinpoint kind of specifically, what is it? What's the nature of the dispute? Help me understand, right? Is it dates that are wrong? Is it not you at all? Is it that it says you served 365 days of jail and you only served 364, right? I mean, you know, what is the nature of the dispute? And then we would absolutely start that reinvestigation process with the sources. Have 30 days to do that. Do they take 30 days? Absolutely not. Again, even from a background check company perspective, this is a white glove process for us, right? And so a dispute gets highest priority. Because why? All you're going to do is irk somebody if they're potentially losing a job and you're dragging your feet and you take the full 30 days. Is it legal to do so? Great. Do you want to do that? Not if you can help it, right? I want the disputes done tomorrow, right? Because, you know, we've got a concern here. And if the report is wrong based on some sort of court data that was misreported, I absolutely have a legal obligation to ensure maximum possible accuracy within the report. So I got to get that fixed, right? Absolutely. You know, our job is not to get people denied or hired. Our job is to present accurate data, right? And so when there's a dispute, it gets the white gloves from our side, right? So then, yeah, we perform that, reach out to your background check company, let them know, give them access to the candidate if they don't already have access to the candidate so that they can make sure they understand the nature of the dispute and they can handle it appropriately. Let them go through the dispute process, let them go through the reinvestigation process. And then if the report changes, then obviously you're going to reevaluate your adverse action decision because that may have bearing on whether or not you're going to continue the adverse action. The changed information, if there is any, may not have bearing and it may continue through to the final adverse action stage. But obviously, you know, you're going to do another evaluation of the modified report if there is modifications and then make your decision at that point going forward to either discontinue the adverse stage altogether and move forward with your placement or continue with the adverse action process.
Cool. Thanks.
Yeah. Cool. You bet. Good question.
Well, I know we're all running out of time, so does anybody have any last questions for Jerry? Otherwise, Jerry is a guest expert in our community, so if you ever throw anything in there, you know, I'm certain Jerry would love to you know, respond.
Absolutely. If you think of something later and you want to throw it on the community, I'm happy to answer any questions beyond this. Again, I think it's good information, irrespective of whether or not you're using TruDiligence for your background checks or not, right? This is still applicable to any background check company or process that you would be using. I threw our contact information up there. If we can be of assistance, you can certainly email us directly at the support email. You can get to us online at TruDiligence.com. I'll finally mention that we are fully integrated into Engine Hire. And so in the event that there's an opportunity that we could present to you TruDiligence as the solution for your background checks, we'd love to have that conversation. We'll give you all the time you need. We'll answer all your questions. We love talking the industry. Danny will validate the fact that I'm a chatterbox and I like to talk the industry. And so don't mind questions whatsoever. If in any way we can be of assistance and be a resource to you within your Engine Hire processes, then we'd love to have that conversation.
Well, Jerry, thank you so much for sharing your
Hey.
time and your knowledge with us. And I will say, Jerry and I have had some amazing conversations about background checks, which you might not think is possible, but it's absolutely true. It is fascinating, and Jerry is just so intelligent about all of this.
Thank
As
you.
you know, they just, they're 34 years in business.
Awesome.
But
Thank you.
yeah, thanks so much. I will post this and I'll make sure that everybody can get a copy of the slides as you send them to me, Jerry. Thank you again so much for sharing all of this.
All right, everybody. Thank you for joining us today.